This is a continuation of the hearing of the application of Colito Development Group of Torrington, Connecticut to obtain a special permit and/or variance under the applicable sections of the zoning bylaws of the town of Sunderland for the purpose of constructing a 9,100 square foot retail building with associate site improvements on the premises of Amherst Road, Route 116, tax map 9, plot number 44 in the town of Sunderland. So this is the fourth continuance we've had on this. So I suppose I should probably send you guys the agenda.
As loud as you can be would help. Thank you. Can we use the mics by chance?
I don't think the mics do any amplification inside here. I will try to speak up. That's pass it on to Stuart. That's something that my wife rarely complains that I speak loudly enough. But okay. The first item on my draft agenda for today is a further discussion of an item that both Rob Levesque and Michael Pill presented at the last hearing. It had to do with the driveway separation town bylaw and the argument that that bylaw doesn't apply in this case. And when it came to us, I said, I'm going to have to take some time and discuss with town council on this because it was kind of a matter I was not familiar with. There's been some further developments on that. Today, it was actually this morning, I discovered and found the A&R that created the parcel. It'd probably be best if I show one. And I have copies of the A&R from you, from the planning board. And if I could steal your easel, Bob, I will put this up there. Okay, the argument that was presented by the applicants was that the parcel known as 99-4 predated the parking area bylaw that was introduced in the town of Sunderland, I think sometime in 1999, and the creation of this parcel predated it. And the argument was that because of that, that bylaw did not apply. The driveway location did not have to meet our driveway bylaws, our drive design bylaws. Now, I noted all along that the parcel 944 that they were referring to was, actually it shows here, was the whole thing. Now, there was a parcel that appeared at about 2015 that is parcel 100, and I did find an A&R. I found it today. It was an A&R issued by the planning board, and it's all signed off and dated January 14, 2014. And in this A&R, which it's the A&R is a term that means approval not required. People can come and cut up their parcels and make changes to their parcels. And what happened here in January of 2014, G.B. Jackson, who is the owner of that property, the whole property, came in and he presented a approval not required that locked off this part of 9944. And it even says in the description, it says this parcel, and they're referring to it on this drawing as parcel A. It says parcel A is a portion of 9940 or 944, and it shows what the area is and the frontage is. It also says the remaining portion of the land of 944, the remaining frontage has been reduced to 48 feet or 408 feet, and the remaining area is down to 2.966. So, and this was approved by the planning board. All of them signed off on the A&R. It's dated 1/14/14.
Well, where was it recorded? The recording is blank.
The owner didn't record it.
Then it
Well,
doesn't count.
that is not, that, I discussed this matter with town council, and it's, Mike, I don't know if you want to speak to that, but this is an A&R that created that, and our position is that the new 9944 or 944 came into being in 2014 and is therefore subject to that parking bylaw. Mike, do you want to elaborate on that?
I'm happy to, Steve, and just to give a little context for the board and folks in the room, the genesis of this issue comes from the provision of the Sunderland zoning bylaw, and that's in section 125(3-1), which deals with driveway configuration requirements when you're undergoing a review by the Zoning Board of Appeals. And those new requirements came into effect with an exemption. They said that unless precluded by lot configuration in existence on the date of adoption of this zoning bylaw. Now, these driveway requirements were last amended in 1999. And so if the lot configuration existed prior to 1999, it would not have to comply with these requirements that came into effect later on. On the other hand, if the lot configuration was changed after the effective date of the bylaw, which is 1999, then any proposal would need to comply with the requirements of the Sunderland zoning bylaw specific to driveway distances between entrances and exits onto a state-numbered highway or a town road improved under the Chapter 90 program. The question here legally is whether the application and endorsement on the approval not required plan from 2013 or 2014, and Steve, correct me if I've got the year wrong, was effective to effect a change in the lot configuration, even though that plan was never recorded at the Registry of Deeds. And while there is no case law that is directly on point, there is an analogous case as well as the statutory text of the subdivision control law. And that has led us in previous cases as well as this case to opine that the subdivision plan is effective, that it did change the lot configuration as of the date of the endorsement of the plan, even though it wasn't recorded at the registry. Therefore, the driveway separation requirements in the bylaw apply. And Steve, if it'd be helpful, I can explain the analysis a little further on that, or I can pause for questions.
Why doesn't he cite the case? Law is reference to authority, and so your attorney has referenced statute and case, and it would be really nice if he would provide us with the citation to both, please.
Well,
Otherwise, he's got
do
nothing.
you think, I don't know if I want to deliberate and argue this case in front of this particular hearing, but is that appropriate, Mike?
I really take your lead, Steve. I'm happy to go into some of the details now. I'm also happy to provide either to speak with the applicant and their counsel offline and also provide information in writing.
And I'm happy to give you a citation in the case that I can give you off the top of my head that shows that your learned counsel is in error.
Well-
The case, and may I give you that case, and perhaps he might want to look it up because it appears he's not aware of it?
I think this is, Mike, we got two Michaels, dang it. Mike,
You can call me Michael and him Mike, how's that?
well, Mike, I don't know. I'm tending to think that this could occupy the whole hearing. I don't know if this is better to be taken offline. And then you guys can, take off the gloves and have at it.
Steve, I think what I would say is I really defer to you and the board, and if you have other items. So if you think it would be helpful to, hear the conversation between counsel for the applicant and myself, we can certainly have that conversation now. But if you have, other elements of the application to consider and process, your time may be better spent doing that, and myself and applicant's counsel can discuss these citations, dig into them offline, tomorrow in the coming days.
I would say that we have a lot of other, this is not like the final issue that's before, this board as far as other things that come into play for the special permit. We have other items on my proposed draft agenda. I don't know, board, what do you think of it? I know the board really, I will say that the board has not been in the many discussions I've had with town council and my discovery of the A&R, and they're not as familiar with the nuances and the matters that are being discussed here. Our town council is looking to us to decide, do we want to have them slug it? I don't know if you're, Michael, I don't know if you're prepared to cite cases or whatever. I don't know if that's going to take.
He's obviously prepared.
Mike, Mr. Bill?
Okay, he's obviously prepared.
This was something we just discovered today, so I don't know how much.
What is the impact of this?
This is one matter that involves whether we can deny a special permit based on this if our standing stands. But there's a lot of buts to it. Because there was other issues, Michael D, that there are other issues of this letter that we would like to address. And let's put it this way: we're not going to be making a decision whether to grant or deny this special permit today. We got a lot of other things that we want to go through. So I'm thinking that our time would best be suited that we go through what I had to present today on this, and if there's arguments between the attorneys, let them take it offline and deal with it. How does the board feel about that?
I would say my proposal would be after that for them to bring some sort of summary to the next meeting.
Well, that would be the thing that we would, that would be my idea, is that, this hearing's gonna get continued for other matters.
How do we know that yet?
Well, why do you think otherwise?
So if I could respectfully just address the board briefly, just to kind of reframe the discussion.
And
So-
you're Rob Levesque?
Yes.
You're the...
Yes, so for the record, and I don't know if there's cameras now or there wasn't before.
There's
So-
cameras somewhere.
okay, so we can speak in, so, good evening, for the record, I'm Rob Levesque from our Levesque Associates. To clarify, an A&R is an approval not required plan that gets endorsed by the planning board. If it doesn't get recorded, there is no new property lines that are put on record. I think Mr. Pill has case law to that effect. We are here to present the entirety of the project. We have no question, no concern that these property lines, although contemplated and although approved for recording by the planning board, never got recorded. And I think by admission of town council, as well as by the chair, it sounds like those never got recorded. So as
And
far as we're concerned,
can I ask, whose responsibility is it to record an A&R?
it would be, Mr. Bill, would you like to speak to that?
It's, in fact, your council has completely missed the mark in terms of real estate law. The issue is not just the recording. The issue is that to create a separate lot requires an instrument. And if he's not willing to cite authority, I am. Patel versus, no, let me give him the citation, please, because I'm ready to put my cards on the table, even if he is not. Patel
Well,
versus
hold on.
planning board.
Michael, I'm
I'm
going
not
to
interrupting
interrupt you. I'm going to interrupt you right there because you're making an allegation about my state of mind that you don't know. I'm happy to discuss the details, and I also welcome any additional new information because none of us has a monopoly on every case that is out there.
Then let me give him
All
the
I can tell you.
information. And he should stop interrupting me, please.
Go ahead, Mike D.
You're,
So Attorney Pill is about to
Yeah,
cite case law.
Patel versus Planning Board of North Andover. It's a published case in the Mass Appellate Records, Mass Appellate Court Reports, I believe it's 1989. The point of that case is that regardless of whether the plan is recorded, a plan cannot create a lot. That requires what's called an instrument, a deed. In Patel versus Planning Board of North Andover, a subdivision plan was recorded showing crucial easements for the subdivision. There was never a deed from the developer to the municipality creating the easements. What the court pointed out was the intent was clear, but the formalities required by centuries of Massachusetts real estate law were not observed. So even if it was recorded, and I've seen this happen before, the recording of a plan does not create a lot. There had to be a deed that separated these parcels' ownership. That's what created a second lot. Now, as you probably know, I'm the author of a multi-volume treatise on Massachusetts real estate law. It's on Westlaw 28 Mass Practice. I'm sure your distinguished counsel may not have done a lot of real estate conveyancing because this goes back centuries and the deed is the essential element. Without a deed, there is no separate lot. Now, if he's willing to do as I've done and cite cases and not shove us off somewhere else, then we could have a discussion that might help everyone. Because what he's done is he's thrown down a gauntlet. And he's not going to change his position,
Okay,
and that's backing us
this is
into a corner.
exactly the weeds I don't think the zoning board needs to get into,
Okay.
okay?
If
Right.
if the lots weren't separated before 99, then the driveway governs, the driveway bylaw governs. Is that correct?
Say that again, if
If the
the,
lots weren't separated before 99,
no, they're saying the 99 is when the existence of the bylaw came into place. The whole 99 or 944 was created back in what, late 80s, early 90s.
no, I mean, when was the bylaw changed?
November of 99.
Of November of 99. So this lot wasn't separated before then.
No, it was not.
Neither person is saying that, right?
Right.
So doesn't that driveway thing
I'm missing the point of your question.
Yeah. Because it happened after 99, the bylaw governs.
Bylaw governs.
Yeah, this separation occurred in 2014.
So hypothetically, through the chair, if the division of land did happen by deed, let's just say Attorney Pill is accurate, I'm not saying which attorney is accurate, then arguably the driveway requirements would apply to us. One. But assuming that A&R plan that never got recorded, that did not have a deed associated with it, did not convey any land, so it never happened, then the driveway bylaw does not apply. Regardless of that driveway bylaw, we actually are coming in directly across from the curb cuts as required under the bylaws. So,
You're talking about the one onto 116?
yeah, we're right across from the one across the street, and we're right across the one from Clark Mountain Road. So, what we'd love to do is let the attorneys duke it out. They make a lot more money than the rest of us. And maybe we could move forward with the rest of the agenda.
That would be my preference. Let you guys have your fun that you enjoy, but I don't think really the zoning board may even not fully understand, and we don't have to understand the nuances of this, other than what is the determination of this lot, and does this bylaw apply? And our contention right now is that it does, but we'll leave it to.
Wait, so just to clarify, it's our contention? Or
Yeah,
It is.
That is not our contention.
Right.
Well,
That is your contention.
it is my
The board
contention.
has not reached a contention.
No, the board was not involved in the discussions I had with town
So
council.
I would like to come back to Amanda's suggestion, which, if that's how it's gonna go forward, that we get either one or two summaries, one summary if they agree, or two summaries if they still
Yeah.
disagree.
Yes, I would,
Is it
I would
ultimately
say.
this board's decision?
I would say that, I think it's safe to say this hearing is going to continue. I mean, and at that continuance, I would expect that an agreement or a summary or a decision between these two guys would be able to be announced. Does that sound reasonable, Mike D.?
It does, Steve, and I can tell you just a couple of points here in summary. First, I always welcome new information. I often change my mind because what guides me is the law. What I don't do is try to assume what's in somebody else's mind or make assertions as to their motives and values. I think that's inappropriate in a profession such as this, where what we are trying to do is to find what the statute says, where often reasonable people can disagree. So it may be that we're able to come to a consensus, myself and the applicant's counsel. It may be that we're not. But either way, we want to provide the board with full information from either both sides or one side, depending on where we land, so that the board can make an informed decision. And I think that we're unlikely to be able to do that on a telephone conference right now, to really get into the details. The second point I want to make, and this is just for the board's general knowledge, this is an area where I agree with applicant's counsel, is relative to the law around taking. And so one of the issues for the board to be aware of is, in my opinion, we could not apply the driveway separation bylaw in such a manner that there was no access onto the property, right? We look at the Lucas case out of South Carolina, and that would basically foreclose all economic uses of the parcel. That would be a regulatory taking. And so one of the other questions that we have to consider, where the driveway separation bylaw may apply, if we determine that it does, we also have to be able to provide some access to the property in order for it to be valid. So I just share that with the board as some further context.
Thank you.
And I don't know, do you want to get into the details of that, or just let that be and let
I think we can take that up along with, the detailed legal memo for the board to consider. Again, it may be one memo from both of us if we're on the same page. It may be two separate memos.
Mr. Pill, is that agreeable to you?
Well, it sounds like he's as familiar as I am that the tenor of the U.S. Supreme Court is much more favorable in recent decades to property rights than to municipalities. And so if the first issue becomes irrelevant, then that's fine, and the second issue governs. With respect to the first issue, Patel versus Planning Board of North Andover is the cornerstone of my case, so
Okay.
I'm not sure how much dialogue we need. It sounds like he and I are both familiar with the regulatory taking case law, especially from the U.S. Supreme Court. So, and if, obviously, if your council's conclusion is that the regulatory taking issue means that the bylaw cannot be constitutionally applied regardless of what the issue is with A&R, deed, recording, or whatever, then we can both save our clients a lot of money and time. So I guess I'd say that ball's in his court, and I hope he would, let us know where he concludes on the regulatory taking issue, because then I can sit down and shut up and y'all can get back to work.
Mike D., I don't know how you feel about that. We have talked about that offline between the two of us, and I just don't know where, did you want to step in that one? Or?
Well, I think what we need to know, and this may be a further offline conversation, is whether there is any access under the driveway separation bylaw if it were to be applied. And the reason for that is because, in that Lucas case, in the Supreme Court taking case, it basically said that a regulatory taking generally forecloses all economic value, right? If it forecloses 95 but not 100% of the value, it's not a regulatory taking. In a way of saying, it may not be how you want to use the property, but there is an economically beneficial use, is not a regulatory taking. On the other hand, if you could not access the property at all, you could not build any driveway to access it, then that would foreclose all economic use and would be a taking. And so the question really is, and this is what I think we need to discuss, is there a way to access the property if the bylaw were applied as written? And what I just can't tell from the existing paperwork whether there is a spot between the different colored lines where access may be possible.
If I could, through the chair, Attorney, is it okay to call you Attorney Mike? Because I'm not sure what the last name is.
Sure,
Mike
absolutely.
D. Call you Mike D. Attorney Mike D. Rob Levesque again. I don't know if you're watching on TV or closed circuit TV. We have an exhibit. It is dated 6/03/25. It's provided also as a graphic on the memo for Green Miles Lipton LLP, dated June 24th, 2025. It very specifically shows that all access points to the property would be eliminated if the driveway bylaw were utilized. We have separations from each of the driveways, roadways, curb cuts, etc., across and on the same side of the roadways. So that graphic, I think, is probably what you're looking for. So if you don't have that already, we'll certainly provide it.
He does.
Okay, great.
Thank you, Rob. And I think I have that I have in front of me, but it may be helpful to confirm afterwards that I'm looking at the right one. And specifically, it looks like there's an area where there's sort of a gap between two of the lines where there might be an access point, but I just can't tell it, how wide it is. It may not be wide enough for a car to drive through, in which case it's not practical access. So just a little bit more detail on that I'll want to get into.
Absolutely, and I respect that question. So I believe you're talking about the area where the 250 radii
Correct.
Join each other and know there's not enough width for access. Further complicating this is that Mass DOT is the jurisdictional authority on, Amherst Road. So we are going through the Mass DOT process for the curb cuts. We have our traffic engineer that is obviously communicating with Mass DOT as we are. So to clarify that graphic, there is no room for access anywhere on this property, provided we respect all of the bylaw, which we still think doesn't apply, but there's no way in if that's the case, I guess is the bottom line. Thank you.
So I think that's worth us following up on, because we may, we may end up agreeing on the first question. We may end up continuing to disagree. But, you know, what I'd like to see is something showing, you know, whatever that distance is, and I don't know how many inches or feet it is, and then the board can make a determination that says, you know, if it's 6 inches, obviously that's not real access, and therefore, you know, the bylaw can't apply as written. But having that level of specificity, I think, will be helpful for the board, so they can make a determination as to whether that access is or isn't there.
And that graphic, through the chair again, that graphic is color-coded based on the different required separations. So if it's across the street, it's a certain color. If it's on the same side, depending on the nature, if it's a curb cut versus a street versus an intersection, those are all color-coded. So we're happy to describe that. Should you get a chance to review that in the time to come, we'll be happy to, you know, clarify that for you.
Great, appreciate it. Thank you.
Thank you.
So what we would like is for the two mics to take this discussion, argument, or whatever offline and address those two issues. And at the time of our next continuance, whenever it may be, we had hoped to get some legal opinions that the board can deal with.
Well, he's got apparently.
He does have that. I did send that to
And
him.
he's got the citation that I gave him, and so I look forward to receiving whatever town council has to say or write, and we can take it from there. Thank you very much.
I suggest you guys set up a date and,
Well, I need to get, he's got our side of the story, between what I've said tonight
Right.
and what I put in writing, so I've just waited, we can set a date
Yeah.
as soon as I get his side.
so, can you guys get together, pick a date, and then I mean,
I just don't want to chew up time. In other words, he's got an argument, but he hasn't shared his legal authority like
okay, I understand that. Can you guys get together and exchange information? I mean,
Yes.
Outside.
isn't that,
Well, I hope he will do that. Thank you.
Well,
Yeah, I'd be happy to talk to him.
it's a two-way street. I mean,
Attorney-
do I have to say, you will call him, or you will call him? I mean, come on.
Attorney Mike D., Rob Levesque here again, to help facilitate. The best contact information for you is what?
Let me give you my cell. Feel free to write it down. It's generally available anyways, which is 781-801-4317. And I welcome a call and happy to talk at any time.
Thank you, sir. Appreciate it.
But all I can do is say, please send me your memorandum and please
Well,
provide me
please
with
do
the
that.
citations, which I've just done. But I'll be happy to call him and leave a message that says the same thing.
And-
That's all I can do at this point.
I hope you talk to him personally, not have to leave a message. And if you could share your exchange, if you could exchange your,
I
781-801-4317.
try to pick up, I will say, but I'll add that I often find that just talking can be helpful, especially when you've got two attorneys. You can work through a lot of items more quickly talking. But you know, if writing is preferred first, I'm also happy to do that.
if it requires a face-to-face meeting, make it so.
I'll be happy to give him a call and maybe we could meet by Zoom, which is the next best thing. At least we can see each other. I'll
Sure,
give him
absolutely.
a call tomorrow. Thank you.
Thank you.
That was fun. Okay.
For the
So,
lawyers, maybe.
come on, share the fun. Okay, so, that issue is going to be discussed and opined, and like I said, I just wanted to share that we did find that A&R, and I'll just make an editorial comment that, and I see it happen on filing special permit decisions are supposed to be filed at the Registry of Deeds. It would shock you to see how many don't get filed. And my understanding is that it's the responsibility of the the person that receives a special permit. I know that's the case. And I think it's the responsibility of the person who receives an A&R to file it. And sometimes they forget, sometimes they don't do it because it's, so,
And sometimes plans change.
and there's Kate, I got Exhibit A right there.
Steve, can you just quickly clarify, they did receive the special permit, is that correct?
Oh, no,
That
they- no.
document shows.
No. These people, this special permit is still being,
Not this special permit, but
this is not a special permit. It is a approval not required. It's pretty much a plan that,
Yeah.
If
So-
they brought that in,
So
if they
can-
had brought that in, would that have?
No, so can I clarify, really, sorry, as a member of the board. So when somebody presents an approval not required submission, it's essentially saying they don't have to get a special permit or the approval of the zoning board or the planning board. What they need to show essentially is a plan that all the planning board looks at is whether the newly configured lots comply with the frontage and other requirements of the zoning code. If they do, then we have no choice but to endorse them.
And when that was signed, then you approved that?
I mean, I wasn't on the planning
I know,
board in
but I mean,
2014,
that wasn't
but the planning board got that submission as an A&R, presumably, looked at the configuration of the lots as contemplated, made sure that they complied with the dimensional requirements of the zoning code, and then endorsed it, saying, yes, we approve it.
and I would say there's two disclaimers on here. It says, planning board endorsements shall not be construed as either being an endorsement or approval of the zoning bylaws, requirements of the town. And another one, there's a second one. It says, endorsement of this plan does not certify compliance with zoning of any town bylaw or regulation. So, they look to see that it's proper, and I mean,
Yeah, and if we get a, I can tell our process, if we get a plan that,
I'm sure you get some crazy ones.
Right, and if it's not what it needs to be, then we send it back.
You don't approve
We
it.
don't approve it.
Just to the chair, what he said is exactly correct, and what I think supports what I was saying is, and it's chapter 183 or 184, section 6A, if you're creating a new lot, you cannot lawfully record a deed without the planning board approval. So you see, it's not the planning board approval that creates the new lot, it's simply a precondition so that when a new lot is created, along with the deed, you've got a plan that shows at least it went by the planning board. And am I making sense? It's like a preliminary
Some of it
step
does.
to the creation of a new lot by deed. Thank you.
Okay, I hear your point. Okay, so shall we move on to the second agenda item? And Mike D., I don't know if you are suffering from insomnia, you're welcome to stay and listen.
Excuse me, ask a
Hold on a second, I got a,
quick question. This issue
who are you?
I'm Jen Snedeker. I've lived in Sunderland for about 25 years.
Okay.
Is this thing we've been discussing, the dollar store? Where they want to put a dollar
Yeah.
store?
Dollar General is, they're the developers for the Dollar, yeah.
Okay. Is it appropriate tonight to the general public to voice their?
No, we've actually, I mean, we've actually had a lot of discussion, and we can have more at the end, but it's not really germane to today's agenda.
When you say the end, what do you mean? Like tonight or?
Well, it's not gonna end today. I mean, we have a lot, the zoning board has a lot to look at in this case. And
So it's gonna be an
we've
ongoing-
already had 4 continuations.
Okay.
I'll bet the house we're gonna have a 5th one, so, and maybe even more than that. So that would be a better time to put on that kind of, that kind of input, so.
Okay, thanks.
So Mike, I'll leave it to you whether you want to buck out or if you want to stay.
Mr. Chair, I'm available at your discretion, and if you feel that I would be helpful later on, I'm happy to stay. Otherwise, I'm happy to
I'll
save
call-
the town money and sign off.
I got your cell number, I'll call you back.
Yeah, I'll be available if needed, and I want to thank you, the board, the applicants, representatives, and council for their time tonight, and I look forward to continuing this conversation tomorrow.
Thank you.
Okay. Thank you, Mike.
Have a great evening.
You too.
Good night.
All right. Okay, let's see. What I have next on the, this is sort of a carryover from the agenda from our last hearing we never got to. You have made a different layout, and you provided us with drawings, Rev B drawings. I don't know if you want to briefly go over that, and you also provided some new elevations.
Yes, sir.
So this, I'm trying to think, I didn't even send it on to the, I do have these in electronic form.
Okay.
I just haven't sent them out to you guys yet.
Bless you.
Just before we get into that, I did post documents on our website, the ZBA zoning board website for the town of Sunderland. I was a little late in putting it, I'd forgotten about it, but there are several documents, including the latest plans, the Rev B plans are on the website for viewing. The letter that Michael, the two Michaels were talking about is up on there. And the elevations are on there, so I was a little bit late in getting it on there. I forgot about it, but it is up on the website for those that are interested. Rob?
Thank you, Mr. Chairman. Again, for the record, Rob Levesque from our Levesque Associates, president of our Levesque, and we are the civil survey, site, landscape architecture component of the project. We designed the site originally, as discussed, had a different orientation. In talking to the zoning board of appeals in the last public hearings, we basically decided that there may be a way to be less impactful, potentially improve on the circulation patterns, curb cuts within the site. So what we did is we basically reoriented the building so that it was 90 degrees to the street, would have less aesthetic impact, as well as having the parking on the side of the building. Allows us to reconfigure the location of the curb cut off Amherst Road, specifically directly across from the curb cut for the plaza and the Dunkin' Donuts to the, I guess that's to the southwest. And also reconfigured slightly the curb cut off of Clark Mountain. We have the parking spaces, which are approximately they are 46 parking spaces. We have the refuse area and loading area at the back side of the building so that that doesn't impact visibility from the street, which was previously kind of on this side. Generally speaking, we've met all of the parking requirements. We believe we've met all of the access requirements. We have run truck turning movements through the site with regard to vehicle drop-off. You'll see that there's this long apron here. That is for the truck turning movements. As you can imagine, to get into the site, you want to be able to back into the loading area. There are, on occasion, tractor-trailer trucks that will be delivering. A lot of times they're smaller, but there are tractor-trailer trucks that will periodically be delivering. So this is the overall layout that was, I guess, informally discussed previously, at least in general format. This has been refined. I'd be happy to stop there. Emily Buck is here this evening. She is our traffic engineer from Bowman. I think Michael was here last time in her stead. She decided to go ahead and get married. Go figure, right?
Oh, there.
So anyway, so she's available this evening to discuss the revised traffic report. We also have a revised stormwater report. I know that there was some questions and comments in the past. Generally speaking, we have very specific requirements for stormwater. Happy to get into those should you want to entertain that later. But for now, I'll probably stop there, and then through the chair, I'll be happy to answer the questions about circulation, and then I can transfer things to Emily, or however you want to do it.
Well, I think one of the things I like to ask, and one thing I'll note, at the first layout, you were actually going to have the tractor trailers pulling through the parking area, and I see that you've made a change where now the tractor trailer, looks like all deliveries will be coming in from Clark Mountain Road.
Yes, sir.
And it would negate driving through the parking area. There was some concern about driving through.
Separating passenger car from deliveries.
Right, and you get a nice little turnaround there. I just want to note that because you made that change. The new driveway location across, that's from 116. Now you say that's directly across the Dunkin' Donuts entrance?
Yes, and also directly where Mass DOT has requested that we shift it. Originally, it was farther up the road. So as part of our redesign, and one of the driving factors for the curb cut location was the comment from Mass DOT. I think it was a 25% comment from Mass DOT, basically addressed that, asked us to put it at a certain station point. That's where it is, directly across. Again, we're directly across from the subway exit onto Clark Mountain with our entry exit over there.
Board have any questions or comments on this revised layout?
Steve, just to help me with the layout, maybe it's easier on the bottom.
Sure.
On that, could you put on either one, can you put your finger on where the oak tree is? That is on that.
You say the oak tree?
Yeah. Is it off the lot or is it in the middle of the lot?
The existing.
Existing.
Yeah, existing.
It'd be in a picture.
Oh,
You gotta,
Somebody want to show me which? Sorry.
maybe it's in your right hand.
the aerial, is that the aerial photo?
What was it? Yeah.
It's further back.
Is it right here? I think that's it.
No, it's further into the site.
Yeah.
I'm just trying to.
Sorry. Move the chair. Is that what this is? That one? That one. Okay. So the oak tree that I believe Mr. Beckley is talking about is roughly top.
Okay.
Here? I'm sorry, there's another one here. It's 26-inch or 28-inch tree here. That's not it.
Will they remain?
Right here. Right here. It's right there.
Thank you.
Yep.
So is the tree in question staying or going, or?
How it lines up on the site.
Okay.
As you see it, as you drive by today, where the building's gonna be, it's gonna be to the.
And is that tree's going, or?
That would definitely go.
Okay.
Yep.
Regrading.
One of the asks that I made, and you complied with, that you have some elevations that are closer to scale to this. Do you want to, can you talk to that?
Sure.
This is at a somewhat different scale than the other drawings. Actually, but this is closer to what you had been submitted before.
Yep, so just to orient everyone, if you're looking, pick the right one.
From 116 is this,
The middle one.
just the middle, that's that one.
Yeah, it's looking straight across
Yeah, so
from
this would-
Duncan.
This would be the view from 116, so the building before was obviously longer towards
Yeah.
116, this kind of truncates thing. This would be the view if you're coming from Amherst. So the proud corner here with the glazing. On the far side of the building,
Yeah.
originally there was no,
Right.
really no articulation of, facade. So what we've done is they have a brick shelf here. They have, I guess we call it shutters, faux windows, shutters, et cetera,
Yeah.
along that whole end, and then the roof line here. So this really is the only, basic elevation, which is to the back at the loading area. But everything else is basically hardy plank siding, trim, you know, and then slightly taller roof, but still staying into the requirements. And again, the materials and, you know, combinations are, you know, kind of so malleable a little bit at this point, you know, so if there's certain questions or concerns that really, they would be more than happy to try to address concerns.
I will tell board members, this is kind of new to you. I received them like late last week, and I have not forwarded a lot of them to you, so I apologize for that, and that's why I asked Rob to touch on that, so.
Good.
If you have thoughts, we're happy to take input.
Just, can I ask a question?
Sure.
Is there signage on the
There
building?
will be, yes, yeah. We'll have to develop to meet the sign requirements. I could ask the architect to show that. They did not in this elevation, but I certainly could.
Do you have any idea where, just
I
up?
would believe it would be here and here, if permitted. So, right here and here. Typically where it would be. I might even have a picture of some that are just recently built that I can show you. But
I think your note said that's where the sign area would be subject to,
you know,
Any
zoning board
regular
approval or
size,
something like
right.
that. It says. So,
I have just another question on the second, yeah, that one down. On that one, can you just remind me where the lot line is on that one?
So the existing lot line is, well, it's way over here. So, right here would be, you know, potentially a proposed lot line. But right now, this is where the line is.
So it's
With
the red,
all attorneys' conversations aside.
so the picture with the driveways, right? That whole red section
Yes.
is the current lot.
well, that's
That's the lot, right?
That's 9-44 and 9-100, right, on this drawing.
That is, so that, just to clarify, this entire lot is the subject parcel at this point.
At this point. That's what you're applying for the special permit for, is that lot?
Correct. We're
Okay,
applying, yeah.
thank you.
Questions on that aspect?
Okay. Thank you for submitting those, and again, I will pass them on to the zoning board. Victoria. And they're actually on the website. You can actually download them from the ZBA website. The stormwater report is a monster, so.
A little light reading.
277 pages of light reading and about 35 meg of, too big for an attachment.
Excuse me, I have a
Yeah.
question. David Job, 20-year Sunderland resident. Are we approving the removal of the vegetation in the watershed district? Is that part of the exception that they're applying for?
I mean, that's part of the
Part of the
demolition. I mean,
construction.
that's,
It's part-
I don't
it's
think
part
we're
of the
going
overall project.
specifically into that.
We
You know,
don't-
this parcel is in the watershed district.
Yes.
And it actually is subject to a special permit from the planning board. So it's kind of weird that I can't think of a case we've ever had where like, you know, both the planning board and the zoning board sort of having, you know, authority over the same use, the same parcel, so.
So the vegetation removal will be part of an exception that was granted from either you or the planning board?
Well, I mean, if, in the absence of this, I mean, if part of it would be the demolition and the preparing of the site for, you know, whatever they're doing. I mean, that,
So through the chair, we do have to meet the performance standards of that district as well. Is there a specific question about removal? That most of the area is a field, as you're aware. There are some mature trees that will have to be taken that are obviously where our site is going. anything around the perimeter that doesn't need to be taken, we would certainly not plan on taking anything beyond what we show on our plan. But there would be some area in here that does have some mature vegetation. A lot of the perimeter plantings, we won't control this area in the future, but along the edge, if it doesn't need to be touched, we won't touch it. So I don't know if there was a specific question about vegetation.
I mean, I want to find the criteria here. When we get to the end of this process, the zoning board will need to decide on making whether to grant or deny a special permit. And it'll be based on, there's like 7 criteria that we take into consideration. Special permit shall be granted by the special permit granting authority only upon its written determination that the proposed use will not have adverse effects which overbalance its beneficial effects, either on the neighborhood or the town. In view of particular characteristics of the site and the proposal in relation to that site, the determination shall consider each of the following, and there are 7 of them. Number 1 is the social, economic, or community needs which are served by the proposal. Number 2 is traffic flow and safety. Number 3 is adequacy of utilities and other public services. Number 4, neighborhood characteristic and social structures. Number 5, qualities of the natural environment, and that's probably where this falls under. Number 6, impact or potential fiscal impact. And number 7 is impact on drainage or stormwater management. So both of those sort of fall into this the stormwater drainage report and some of the things that we'll be getting into. So that's what the board will be looking at. That the proposed use will not have adverse effects which overbalance its beneficial effects. That's if it doesn't, you grant. If it does, that's basis of denial. So that's really what the board is. That's when Judgment Day comes. That's what we'll be reviewing. And so we're trying to gather as much information about these things to formulate that decision. So,
through the chair, we have provided through the application package a response to each of those items, those criteria specifically. As you are probably aware, in the 200 and some odd page report, we have addressed all of the DEP stormwater management standards for stormwater. We've addressed all of the requirements for treatment drain, water quality, stormwater attenuation. All of those components have been met with regard to drainage. With regard to the environment, this site is not necessarily unique, other than the district it falls within. It's obviously an open field that's maintained. There is some mature vegetation, but in general, there's no other criteria. We are well aware of where, I know this was a comment from folks in the audience, that we're well aware of where groundwater is. We do test pits before we even start our drainage. Our drainage efforts are typically 100+ hours to determine the proper drainage conditions associated with the site. So we feel confident, and certainly if you have any questions through the process with regard to how we've addressed those criteria, we would be more than happy to meet those, because we feel very confident that we have addressed those and can address each item should you have concerns.
Right. The next agenda item, sort of gets into one of those areas that the board would have questions about, but we got a lot of pots on the stove, so we just gotta wait till they simmer out. I'll state again that it's in the watershed district, and we do have part of our criteria is qualities of the natural environment. So we do have some interest there that we have to make a determination on. Also, one thing I wasn't aware of, I discovered that actually the Cliffside Apartments, which is nearby, they actually have a well that's, they don't use town water, they use well water. And I think part of their aquifer field goes under this area, so that's something that the board would be, cognizant of. This parcel, even though it's changed hands many times and it's been chopped up and combined and all sorts of things, has essentially been vacant and in that state since the mid-70s. So, that sort of serves as, not, and I don't pretend to be any sort of biologist or whatever the proper discipline that goes over this, but it's, it's been sort of a aquifer recharge area, and so, again, I'm wandering into areas where I'm gonna get over my head, so I'll stop there, but, so the board is concerned about potential impacts of, runoff and whatever of this, so. Can you talk?
Chair, just speak to the well comment. So a public water supply in Massachusetts is required to have a well radius for the zone 1, ranging anywhere from a minimum of 100 feet to 400 feet based on the draw of the well or the productivity of the well who is provided to. So that well radius we can certainly show on the plan. We are not limiting the well radius in any way for the zone 1. We are, obviously, if we're in the Water Resources Protection District, we're in the recharge area. That's why we've designed the stormwater management system to meet the requirements. So we have met all those requirements. I invite you to review the drainage, the stormwater report, which details all of that, provides all of that information for you.
Could I ask, the stormwater drainage report is a further agenda item. I'm particularly interested in the subsurface infiltration basin design and how.
Never asked.
What's that?
That means never asked.
And how it works, and assume I don't know. I mean, I'm not a.
Is this basically the same as the original but flipped?
Similar.
Yeah.
Yep, I think fair to say yes.
Yeah.
So in basic terms, I can explain the requirements for what we need to do and what we've generally done. And if there's specifics, I can certainly ask those questions, or our engineers can certainly answer some of those questions. But generally speaking, we are required to look at the pre-development condition. Right now, it's a grass field, right? In the post-development condition, there's going to be impervious surfaces, so it's generating more runoff during storm events. So they want us to, one, we'll call it attenuate flow, right? So slow down, detain, slowly release that water, right? They also want us to look at water quality. There's 10 standards they have to meet. They include recharge, they include, water quality. The water quality is achieved through what they call a treatment drain. So that treatment drain starts typically in a traditional drainage system with catch basins. Everybody knows it's a catch basin grate, right? The water goes into the top of it. Well, what you don't see below that is typically those structures now they're required to have a deep sump. So there's a 4-foot sump below the pipe that comes out of it that the water goes into. It settles into that sump, right? And it's supposed to be clean. There's periodic requirements throughout the year. They're supposed to be clean, street sweeping, etc. So that's the first order of business in the treatment drain. Then it typically goes, prior to going into the subsurface system, it would go into a water quality unit. So we have a proprietary water quality unit that essentially swirls the water around, for lack of a better term, separates total suspended solids, floatables, et cetera, gets removed from that water, and then ideally, you're introducing clean water, or you remove 80% TSS from the system, and then we have, within the system, we have what's called an isolator row that's basically isolated the fabric, so that if that row got fouled in some way, that row could be cleaned out without fouling the rest of the system. There's ports over the top of the system that we're allowed to, or I'm sorry, that are provided for maintenance and, you know, inspection, et cetera. The system itself, if you think of like a big septic system, it's kind of like that, right? So you have drainage that gets, the water gets cleaned, then it goes into the big septic system. We have an outlet control, so the water goes in there, it's controlled. If you think of an hourglass, right? The sand through the hourglass, it's the same thing. The water through our drainage system, it's slowly metered out, just like it would be metered out through a water glass. That's the attenuation component. And then we're discharging through a discharge pipe to an outlet point. So we're basically collecting, cleaning, slowly detaining, and then metering out at the same rate that it was already going to that same design point. So we can't increase the amount of water going to that design point. We're not supposed to, you know, if it was a wetland, you wouldn't want to decrease. In this case, obviously, it's void wetland, so it's not an issue. But that's what's happening. So this rectangle you see here is getting all the water. We're cleaning it before it gets here. The catch basin here, runs into a water quality unit, into our system. Outlet control allows it to go out slowly out of our system and then just discharge. We also have the roof water, which has slightly different requirements because it's not, you know, it doesn't get floatables and sand and grit and everything in like a parking lot would do. So we have an outlet pipe from our roof leaders that goes into the stormwater basin here. They both provide recharge. They both, which they want the water, one of the requirements is that the water be allowed to recharge, especially in the aquifer area, recharge clean water back into the aquifer. We are, I think there was a question, we're required to have a certain separation above groundwater. So two, in most cases, sometimes 3 feet of separation from groundwater for an infiltration basin. So these basins are, we do test bits, we look for seasonal high groundwater, which are redoxymorphic features in the soil. That determines groundwater based on a soil evaluation done by a certified soil evaluator. And then our civil engineers then design the system based on that elevation, so everything's got to be above that. So that's how it's all designed. That's what you see here in plan. In report, it's described the pre-development conditions, described the post-development conditions, described all the CFS and different design points, pre and post-development, the treatment train, the water quality, how we're meeting all the 10 standards is all in that report. Get some popcorn, grab a beer, it's exciting stuff.
Where the water is discharged,
That's right, yeah.
is that like a perforated pipe, or is it just like?
Nope, it's a
It's
solid
surface.
HDPE pipe, and it's just discharged at a flared end with some
So
rubber.
it's
And it's
discharged to
discharged
the
to
surface?
surface?
Yes, sir.
Yeah.
So all the runoff from the parking lots and the rooftops, or does the water from the roof go through the same
Nope.
filtration? That's all separate.
And, so the rooftop runoff goes to a basin here, a surface basin, okay? The water here, not all, and you said all the water, I just want to clarify. Most of the water is handled in the subsurface system, and then it exfiltrates through the bottom of the system. There is a certain amount of flow matching the pre-development condition. That same amount of flow is sent to this design point here. So it's pretty well described. There's a table in our stormwater report that says pre-development CFS to the design point, post-development CFS, and describes all that.
Now, you say you got a filtration system that's going to require some kind of maintenance?
Yes, sir. So the entire system requires maintenance. There's a long-term O&M as part of the DEP requirements. There's a long-term operation and maintenance plan that has to be executed by the owner slash, tenant, and responsible parties are identified. Very specific schedules for maintenance for different BMPs, so best management practices like catch basins, water quality unit, inspection of subsurface systems, street or parking lot sweeping should it be required. All of those are folded in, and that is all based on the guidelines from Mass DEP.
So who's going to be responsible for the maintenance?
I
I mean,
there will be an individual identified that is responsible.
but I mean, this is going to be
So
sold.
this is developed by Colito Development Group. So hypothetically speaking, Colito Development Group will have a tenant, that would be Dollar General, and Colito Development Group would charge them a triple net lease. And either they will be specifically responsible for their lease premises, or if Colito Development does a different agreement with them, Colito Development could be responsible, and then they pay Colito Development to be responsible. Have not seen that document, but either way, there's a responsible party, and that has to be
That's-
identified.
And how good is this filtration system with automotive, what's like petroleum products?
Good question.
And, you know, antifreeze and all other salt and, well, not so much salt, but.
So everything that you're talking about gets picked up on the asphalt, right? So this is curved asphalt, there's collection areas, there's catch basins themselves, everything is graded at a minimum of a 1% slope to those catch basins. The catch basins not only have the deep sump, but I also failed to mention there's something called a hood. There's very specific proprietary hoods that if you envision a pipe, my hand is the pipe coming, leading out of the catch basin, so you're inside the catch basin, this is inside the catch basin. There's a hood that sits over the top of the outlet pipe that actually prevents floatables from getting into that pipe. So that's what allows things to settle out, either in solution, settle out in solution, or eventually as the water goes down, it can be then taken out later. There's very specific street sweeping companies that have vac trucks. They remove that material in the vac truck. It gets disposed of at a very specific location. It can't just go anywhere. And they're doing that on a daily, weekly basis on sites.
Mr. Chairman?
No, at this point, I'm going to have any questions come from the board, and then we can open it up to people from the public. Now, the water that eventually comes out of the discharge, is there some specification on how clean it is relative to the?
Yes, prior to going into our subsurface system, there's very specific requirements that DEP has for total suspended solid removal. And there's certain credits that you get for deep sub catch basins, for water quality units, et cetera. And now it gets calculated, that's all part of the calculations.
Will the discharge be monitored? I mean, is it tested?
The discharge will not be monitored manually by a person, but during the operation and maintenance review that is described in the operation and maintenance document that's part of the stormwater report, absolutely. Someone will be checking the entire system. Outfalls for, more so for erosion or some sort of scouring, that type of thing. Again, it's a fairly flat site, so it's not like we're dropping this onto a 3-to-1 slope or something like that. This is literally a low area, adjacent to the property. So it's going on to almost like a lawn, call it a lawn area. Very subtle. If you drive around, you'll see these all over town.
I mean, it sounds like this thing is going to require some sort of maintenance schedule that's fairly rigorous.
Absolutely. Yeah, that is a requirement for any new site. This is not a LUPL, land use with a higher pollutant load, like for example, an industrial use or something like that. This is pretty standard stuff. So, this is what you would see in any commercial parking lot. The DEP requirements aren't drastically different for, an aquifer area. They're belts and suspenders already, which is good. So, it's what's typically required for a new construction site or a new commercial development.
Mr. Chairman, what you can do is make that, have you ever seen the O&M plan become like a condition?
It always is. Yeah, the O&M plan is typically on a planning board decision or on the ZBA decision.
Becomes part of the record.
It would all be referenced into the decision, and a condition certainly could be provided. Same thing if we had conservation, which we don't hear. Oftentimes they will incorporate all decision document.
Which
Right.
means the town can, it's another belt and suspenders. In addition to whatever other requirements there are, it means
Require them to.
the building inspector can go in anytime and say, I
Show
want
me
to
your
see the
reports.
documentation.
There is also a construction phase. Anytime you're disturbing over an acre plan, there's a construction phase, NIPD Stormwater Pollution Prevention Plan. That's more construction related, but that also is impactful in making sure that there's no issues during construction.
Are these kind of details included in the stormwater and drainage
Absolutely,
projects?
every single one,
Okay.
absolutely.
That's why it's on
And we can tab or, help, break it out. And actually the index of the stormwater report should show all the different exhibits. It's pretty, about half of it is interesting to look at, maybe less, maybe a third. But in the first part of the report, before you get to all the HydroCAD calculations, that's where the meat of what you're probably going to be looking for is.
Questions from the board? Any thought?
So is there a zone around the discharge area where any type of use is restricted? So my question is, you're gonna divide this lot off again, and your discharges are very close to the newly proposed property line for the new lot.
Yeah.
What kind of safeguards that are preventing the outflow from flowing onto that other lot and becoming the next tenant's problems down the street?
Good question. So one, it's discharging on a very flat area, so it's not a steep slope where we're running out into the neighbor's property. Two, we calculate the apron of there's a flared end, familiar with what a flared end looks like? So, this will be likely an HDPE flared end connected to the HDPE pipe. And then from there, we calculate an apron, an energy dissipator, that's calculated based on the velocities of the pipe that are anticipated. And that is a certain distance off of, so these aprons that you see, these are riprap aprons, angular stone, 4 to 6 inch angular stone, that's placed at the end of the pipe to dissipate any sort of velocity. So then, and then from there, it basically sheet flow and dissipate out into, the sandy soils that we have. Again, already treated up here, right? Here and here.
Is it sort of like a swale? Is there like a basin? I mean,
No,
what?
so there's a basin here, but this area, this discharge here, so first of all, the discharge from the roof leaders is pretty straightforward in that it goes just into that basin that exfiltrates through the bottom. This here is a discharge, and again, that's just metering flow out at a certain rate to this point based on what's already generally going there from the site pre-development conditions.
Would you expect that, like if we have a thunderstorm with heavy rain, say we got a 4-inch thunderstorm over a couple hours, is not that unusual. I mean, if you're lucky, you don't get them, but if you do, would that fill up? Would there be a
Good question.
a laking effect there?
No. So that's the attenuation component of the subsurface. There are very specific storm events that DEP has us designed for, and they do have rainfall data in the report associated with each one of those items. So say it's the 100-year storm, based on the requirements for calculation of the 100-year storm, we use the same storm event, pre-development, post-development, obviously different conditions. Those two numbers generate a CFS for that design point, pre-development and post-development. And then again, the size of this is based on those numbers. How big this gets is based on how quickly it exfiltrates through the bottom of the system, what's coming into it, and what we're allowed to discharge based on the pre-development condition.
And CFS is?
Cubic feet per second. It's a measurement of the amount of water coming out. Sorry.
But in the stormwater report, I'm imagining there's probably reporting criteria and reporting requirements that have to be filed with certain entities, probably the DEP and all that. Are there provisions that someone would notify the town of Sunderland if this system somehow started not performing up to par? is the town gonna know that that system is faulty?
It's a good question. I would say that you could add a condition. The enforcement of that condition or understanding that condition is going to be based on the inspection. So, good question. I think it's a good question for any site. To be fair, it's monitoring of the system properly, and it's also communicating with the town properly. For example, let's say you had somebody spilled oil, changed their oil in the parking lot, spilled oil, right? Then they would have to, whoever's operating the store would have to review that, call Clean Harbors or somebody, have that handled properly, file all the proper paperwork. The good news is, if that happens, it gets caught in our system. It gets caught in our net, so to speak, right? It gets caught in the treatment train before getting to the subsurface system. If for some reason somehow it got there, they would need to address that accordingly. But these safeguards that are in place are likely not in place on anything developed prior to 2008. Certainly not to this extent. These regulations came out in 2008. These are the newest stormwater regulations that we're adhering to. And there's also some recent rainfall data that we've increased the calculations based on, because a lot of people are talking about what is really the 100-year storm. There's some more conservative estimates, rainfall data for the 100-year storm, which is based on a 24-hour time frame. So a lot of the new calculations that are done are assuming that new rainfall data. So it's a pretty thorough process that we end up having to go through.
But the enforcement agency is going to be the town building inspector?
So the enforcement agency, there's multiple enforcement agencies depending on the nature of the anticipated problem. So I'm not sure specifically.
Does DEP have authority over this? Or
Absolutely.
Okay.
In some regard, yes. From a wetlands and waterway standpoint, no. But there are certain aspects that could potentially trigger a DEP review or response if there was something catastrophic that happened. Otherwise, it's proper maintenance. If they end up having, over time, if they're not maintained, if things aren't maintained 20 or 30 years from now, you could start to have, it's just like a septic system, right? They sometimes have a shelf life depending on how well people take care of them, or if you have 17 kids like I do.
So that's the point of my question. On the ongoing maintenance, are there reporting requirements
Yes.
for the ongoing maintenance, where you
That's
have to
the
prove
O&M
that
plan.
you're maintaining it?
Absolutely.
And, okay.
And who does the report go to?
Maybe I'm sorry, I'm not describing it well. The O&M plan has ongoing reporting requirements that are required, and your board, as well as the planning board, could condition their decision to have those provided even to your board or to the building inspector or whoever you designate as your agent.
So in the absence of that, where do those reports go?
One,
Corporate office?
depends specifically, but a lot of times they go to the Conservation Commission. Typically, they would go to the permit granting authority. Here, there's no Conservation Commission jurisdiction, so I think that probably would, you guys want them, you guys could get them, but they're required to do them based on the DEP regs and reporting for that. I don't know that DEP necessarily reviews that stuff. I can't imagine.
Well, I just know that, things tend to sound great at the design stage, at the pre-construction phase, but maintenance is the first thing that goes out the window. And,
I don't.
and he's saying, you cited an instance, well, somebody dumped their oil in the thing, who's gonna report that? The employees at Dollar General? It's.
Yeah, so I can't design for stupid.
I know.
Somebody asked me once, we were putting a kiosk up, and somebody asked me, what if somebody parks in the middle of the street and runs out of their car into the ATM and leaves their car running? I'd arrest them.
Yeah,
So, all the safeguards are in place. The mechanism would be to connect the DEP requirements that are in the O&M to your permits. That's the protection. I would have you confer with town council with regard to how to do that for that stuff.
I know that you say, I know there's a big fat stormwater and drainage report that we haven't even got into, and some of these situations and are covered in there. I'm thinking that, I'm just thinking out loud for the board, that we may want to have some outside review or pay for somebody, I mean, because a lot of this is Greek to me. The common sense of part of me says that I fear that the water that's going to get discharged into the ground is going to be compromised by this use. And you can say, hey, when first installed, all the filters work great, everything works great. What happens when maintenance falls down and something happens, and that is a concern for me.
So I will tell you, we have been through hundreds of peer reviews. If it wasn't for the cost of my client, I would be so bold as to welcome that. Because frankly, it gives you the data you need to make a proper decision. We stand by our stormwater report. If for some reason they can find some little detail in our calculations that can be improved upon or clarified, they have to justify their job in doing the peer review. But we've been through hundreds of them, and I will tell you, not one has changed the drainage system. We might be revising little calcs, or maybe there's, make sure somebody signs the illicit discharge, statement or something like that. But, as far as, peer reviews, it will slow the process, but it actually will, frankly, all these questions that you're asking, and we're talking about hypotheticals, kind of go away when the peer review happens. So, in a way, it's, fairly reasonable.
Well, I know that, this particular drainage report arrived late last week, and I forwarded it to the Conservation Commission, to, local experts, to take a look at it, and quite frankly, they didn't have the time to provide a response for today's hearing. So, maybe, if we get to it, maybe just a superficial, presentation on the stormwater develop, I don't know if it's even presentable. I mean, it is, maybe kind of is what it is, but it's certainly, we don't have experts on this board that can look at this thing and say, that doesn't sound right, or that looks too small, or,
We fully respect that. I guess all we would ask is if you feel that way, it'd be nice for you to come to that determination this evening, so if there is a peer review that's going to be requested, we're not just kicking it down the road. To me, we have the traffic information, we have the site information. If there are questions related to that, we're happy to address those, and frankly, we welcome that. Really, in a way, it's going to, when they write you a letter saying that we have no further questions on the stormwater report, there's nothing better for guys like this to address if there was ever a concern about that, so it might be prudent.
I mean, Stuart?
Well, I agree that it's not our expertise. I would have a question as to whether the planning board has started their hearing.
No.
Okay. What I think would be a shame is if both boards ask for it, that would be a waste of somebody's money.
Yeah.
But I think it's very reasonable to ask for a peer review on the stormwater. And even though you referenced that it might cost us, it should be the applicant's cost.
Correct.
No, that we have provisions.
Yeah, I was just saying, that I didn't want to welcome,
Yeah.
charging my client,
Just use TP40, right? You use
But,
I agree.
update stuff, yeah.
I agree.
There's a point that needs to be made that he was too modest about, and I've litigated this issue. Massachusetts stormwater standards still just use TP40, right? US Geological Survey Technical Paper 40, which only has drainage data, I think from 1936 or 37 up to like 1956. And more than one engineer has told me, an engineer can come in here and, or somebody like Rob and say, oh, we satisfied all the legal standards. Well, the problem is, given what's happened in the last 80 years, that 100-year storm is now a 25-year storm. So what Rob has done, and he wasn't legally required to do it, is used modern precipitation data.
But not to bore you, the reality is, you're using modern precipitation data for the pre-development condition and the post-development condition. You're designing for the delta between the two, so it actually doesn't change that much, believe it or not.
Darn,
So-
I'm glad you weren't my opponent when I litigated that last time. Okay, but it's good to know that, in other words, he's doing it right, and certainly what I've seen, and I've used them, you know, Ty and Bond, Bucky Sparkle and Amherst, Berkshire Design, I mean, anybody, the guy at Ty and Bond is named Tim Grace, he's down in East Hampton. In other words, there's plenty of people around who, they do these stormwater reports, and they also do the peer review.
With the university, we have, I mean, I think the Conservation Commission is very much aware of the wealth of.
One of the items through the chair is, if in fact the board does feel that a stormwater peer review is appropriate, which I don't necessarily disagree, I would want to make sure that, you know, in a perfect world, there was a vote taken. We haven't been before the planning board, so to Mr. Beckley's, you know, comment, we would like that the stormwater report is designed, the review process is designed so that it is suitable to the planning board as well as the zoning board of appeals. In addition, I think we want to resolve some of these legal questions, hopefully in short order, before we, if there's a legal battle happening over some basic zoning.
Something else that.
Yeah, we probably want to get just
I
beyond
mean,
that hurdle.
I think fundamentally, I'm in agreement with what you say, that, and usually the planning board chair is here, but I think, any sort of peer review or engineering review or whatever, that it would satisfy both, so we don't get you double jeopardy. I mean, we're not that mean. But there's nobody here from the planning board, or there's nobody in authority, and, by no means, I don't think we're ready to take a vote for the reason that you say, because that would I'd probably do that, at the next hearing. This would probably be a lead item, other than, resolving the thing that we spent the first 3/4 of an hour talking about. That would be part of it, and also we'd talk about peer review and whatever. I know there's a process for it. I'm not familiar with it at the top of my head how that works, but there is. We can request a peer review, consultant review, or whatever that falls on the.
It's chapter 44, section 53G of the Mass General Laws.
Okay.
I mean, but
I don't know that off the top of my head. I know it exists, and when it comes time to cite it, we'll have it. But thank you, sir. Rob.
Do you make any peer reviews, a stipulation, so permits are granted, let's say a permit is granted, subject to a peer review of the water?
That doesn't sound like a good idea to me.
Putting the cart before the horse.
Yeah, I mean, I think, if we're gonna make a decision on, one of the things is impact of stormwater and drainage, stormwater management, and then qualities of the natural environment, I think we need to know the answers to this, before we say, before we start balancing it and saying, is it, does it, detrimental effects overbalance the beneficial, that sort of thing. So I especially something this complex, I wouldn't, pass it off to a stipulation, granted conditional, I'm getting a,
peer reviews are always done before you grant the permit.
Right.
Yeah.
well, I think Rock's maybe trying to facilitate things or whatever it is, but I think it's gonna take whatever time it takes, so. Hold on, any, Stuart?
Just looking for an explanation of why we wouldn't go forward tonight with that vote.
Well, whether we do it at the beginning, we're not gonna be, whether we do it at the end of this session or the beginning of the next one, you were saying that, first of all, we don't have the planning board agreement on what we're talking about. And
Mr. Chairman, we were asked, I believe, I think maybe even by town council, not to apply to the planning board. We actually had applied to the planning board because we felt that it was logical to do these two permits in concert and have input from the planning board. That was our goal. We were asked not to do that. We were asked to go directly to the ZBA first. So.
And that is true.
So we would have preferred to go the other route, but we respectfully, entered into this process. I think what would be logical and prudent would be to request that the ZBA take a vote about the peer review this evening, so that you guys can then secure quotes from, respective engineering firms based on that. And then at the next meeting, you would have those quotes. We would be presented to those quotes. My client would be required to agree to that and pay the fee so that that work can be done. Because it's time, time. And frankly, if we're kicking it down the road, not that we don't have other items, we can continue to address those other items, but at least we would be working towards a peer review. We would have the information that you're talking about. So respectfully, I would ask through the chair, if it's possible for you, if you think the members are going to want a peer review of the stormwater, that we, get that agreed upon, and then I believe you need to go out for quotes, and then provide us that information, and we would agree, and my client will write the check.
And one other point, I think it was actually the same young lawyer who you heard from tonight. I went to the planning board, I wrote an opposing memo, I did everything I could to get them involved in the process, and with the backing of that lawyer, they absolutely declined. And we decided we're not gonna fight with them, we're gonna come to you. But since the planning board, adamantly backed by this same lawyer, took the position that you need to decide first, I think what in effect they've done is they put it in your hands. I mean, if you hire a peer reviewer and whatever conditions the peer reviewer comes up with are incorporated into whatever decision you make, I think the planning board has, quite frankly, made their bed. In other words, they could have, and indeed, if they want to change their mind right now, so we can go forward, the application's already in to them, then that would be great, and they could work with you, and we'd love to see that. But in other words, and I'm trying to be frank, they're not going to be in a very good position if you do the peer review, and then they say, oh, now we want another peer review, and we're going to start all over, after having been so adamant about saying, we're going to wait till you make a decision. So maybe, they'd want to reconsider, or else, I like Rob said, because it takes time. We've both seen that. You got to put out requests, and then the engineers got to make proposals, and so a vote tonight would simply get the ball rolling, because it's going to take a while. Please, please, please.
you make some points I agree with, you make some points I don't agree with so much, but I think fundamentally, I know the planning board made their decision they did. I didn't understand that, but I also know that this is a unique situation. We haven't had a proposal of this type that actually had elements of both approvals from both boards. So it's kind of unique, and we're feeling our way through it. So how they decided to approach it, hey, that's it.
Do you want me to try to explain why we made the decision?
Well, I'll say that Amanda, who is a associate member on our zoning board, is actually a member of the planning board. So we have cross-pollination and
So
go ahead.
we thought, similar to what was said, that if we were both deciding at the same time, maybe you asked for a peer review, we asked for a peer review, or we put a stipulation and you put a stipulation, that they might be competing. And so it made more sense to put one first, and then we would have that as, that was the first step, and then we would take the next step. And so, you know, whatever we come up with, whatever peer reviews, whatever stipulations, that if this goes forward, that will be taken into consideration when we
I would
review the
think,
case.
I would think that, you know, if I can work with the chairman of the planning board to make sure that, you know, whatever peer review would satisfy both. I mean, I think that's, you just don't want to get double jeopardy, you know, and I can understand that.
If it was some other type of review, we would maybe have more concern, but
Yeah.
stormwater peer reviews are
Well,
pretty
it's
defined.
just through a quirk of the zoning bylaws is that projects in the watershed district fall under the planning board. So, but we also have, you know, two of our criteria has to do with stormwater and drainage and qualities of the natural environment. So it's sort of like, you're half pregnant. It's kind of a tough situation to deal with, but we'll deal with it. So, so I think, okay, I'm just trying to figure out, they have to make a motion to,
Make a motion to request a peer
to
review.
put out
All right.
quotes for peer review of the stormwater and drainage report.
So I thought you were steering us away from that, so I'm happy to make that motion if you want.
To me, it doesn't make much difference whether we do it at the end of, I'd be more comfortable doing it at the beginning of the next hearing.
It saves a month.
Yeah.
Well, that's,
So that's the difference.
that,
That's the only.
well, Rob, you had expressed some
Yeah, I would
concern,
like-
but maybe
If
not.
you're going, if you anticipate a peer review, please order it up now.
Yeah.
That'd be great,
Yeah.
if possible.
Based on your experience and expertise, do you expect this to cost more than $10,000?
No, but I'm sure maybe somebody puts a quote in. So the way that,
If someone puts one in under, just telling you that you don't need quotes.
well, so to clarify, I believe, and you know this intimately, the cost of that cannot be disputed. I believe it's only qualifications that can be
Right.
disputed, and it's being paid for by the applicant. So I believe we're okay.
And normally what the engineering firms will do is they'll give you a written proposal saying this is what we'll do and this is what we'll charge for. And then it's up to you to pick. And at least in my experience, 10 grand is, because they're not doing the work.
Right.
They're reading the report, and you've got like somebody with PE, professional engineer after their name, who's essentially saying, yeah, this is okay, but this, and this need to be changed. And then Rob writes a response to it, and hopefully we can make whatever changes they say are needed, at which point you have your person. And the way the statute works, say, is all we get to do is pay for it. You hire the peer review, and we pay the money into an escrow account, so the engineer, and of course that's important in the real world, the engineer sees the money's coming from you all. So they know who they're working for, and you're the one who picked. But that's, I think, part of why we're so concerned about time, because after you vote, you gotta ask for the proposals, and then you gotta pick who you're
We have to
gonna.
receive them, we have to figure out which one to go
It's
with.
time.
I'm trying to think, the last time we did this was actually
Right.
probably during the
Comprehensive
comprehensive permits.
permits, yeah, we did a lot of
We
them.
had to bring, you know, we
Multiple.
got unbelievable reports and stuff, it was well over our head, and we got, so,
Well, and you can even have the peer review engineer, and I don't know how many times I've seen this, have the peer review engineer come to a meeting, and that could be included, and then they answer whatever questions you have.
and I think that's what happened.
And
We
people-
we actually had,
The
yes,
audience have questions, they can ask questions too. And then both you and the folks who come to the meeting know that an expert who works for the town has also gone over it.
I do want to add one thing. I did reach out to the Conservation Commission, and,
I'm here.
well, you're one of them. I mean, I reached out to Jen, and I received a memo from Ellie Kurth, who's also on the Conservation
You
Commission.
also could not be here tonight.
Yeah, and Jen couldn't be here, she's the chairman, but they did come back to me, and, you know, they cited that, hey, this thing just arrived we really can't give a fair analysis and critique of it, and they both suggested, in different words, that having a qualified engineer do a peer review. I'm putting words in their mouth, but essentially
Yeah, we
it's.
voted as a whole board, we're all strongly in favor of that.
Yeah, so I think there's violent agreement here, so I think we can go forward with that. Can we have a vote on voting to go through the process of getting peer review, putting out requests for quotes for peer reviews? I mean, is that a crooked motion? I mean,
Did Stuart make the motion?
Yeah, I would like to make that motion. I would like to make it more crooked. Essentially time.
that's good. Tell the lawyer here, he's listening.
Twisted, is that a better word?
It's not a technical thing, it's just voting, just in effect, just
Yeah.
what.
Voting to authorize, I mean, you know,
Okay.
we're-
Yeah,
Okay, then we'll just do it that way.
voting
I'm gonna
to
say-
Authorize the,
if you want me to say it's not.
Vote to authorize.
I'll take care of this guy, huh? Right. He's trying to
I
save
would
us a
move
month.
that the chair and the town administrator move forward with seeking proposals for peer review relative to stormwater, and just to take the plain word and to particularly note relative to the groundwater aquifer watershed district. I'm not to write all that down. I guess I'll stop there. Could help.
second.
Yes.
Any discussion, any comment? Okay, 5 full-time members, all, Hollis, what do you say? Stuart?
Yes. Yes.
James?
Yes.
I say yes. James, number 2. I will work with the town administrator and I'll incorporate the planning board, just to make sure they're, that they
Aware
are,
of that.
they will have a part in this and that they will be satisfied, so. Okay. So. Okay, were there some questions from the audience or that, on what we've done so far, or at least on the most recent stuff? And who are you? Yes,
Hi, I'm Carrie Klein. I live at 50 South Silver Lane.
I got you,
In this building, it's called Silver Lane.
I got your letter.
First, I want to thank you for really good questions, Mr. Chair, I think. And for going through the special permitting, all 7, which included more than what was discussed tonight, really good points. It also included economic well-being and general well-being of the community. And also on that same page, it talked about public hearings. And this is, we've lost about half of the public that came to speak because we're almost 2 hours into the meeting. We have not heard the public. And I know that there's so much that has to be done. I also know that the mandate of the Dollar General right now is to have over 200,000 new Dollar Generals in the next, while we're having an economic downturn and developers want to develop and lawyers want to talk. And the public hasn't spoken, and I wonder if you would consider having a public hearing to hear the public.
Well, that's what we've had. We've had, and I know we've had 4 continuances, but one of them was, we opened it, set a new date, and yeah, but and I believe at each one of those, we had public input.
But it's always been the same, like in the last, maybe one time it was an hour, but the last little bits, where
Well,
the developer and the lawyers speak for most of the
I'll
time.
say that I've received, written communication, that I mean, we gotta have some sort of order to these hearings. I mean, you know, we try to do, you know, stuff from the applicants, and then we go back and forth, and then we open it for comments. We've, you know, I think we give, I mean, this is your time to talk, and, you know, our next hearing, we'll have another, you know, public comment, you know, session, but, you know, we'd like the public comment to be pertinent to the discussion that we had today. I mean, we've had, you know, some of the things you raise about Dollar General and their, you know, mandate to have some, that is not of concern to the zoning board. I mean, we'd like comments relative to the decisions and what we have to do as a board. I mean, that's, I'm not here to, you know, say what kind of retailer, you know, this company is versus another company, that this one's better than the other one. That, you know, we consider, you know, social, economic, or community needs the proposal, we can take that into play, but, you know, we got much other bigger fish to fry here in trying to come to a decision on whether to grant a special permit. I hope you understand, and I did get, you know, I believe it was you that sent the letter to the town clerk. Was it you?
It was.
Okay. Yes.
My name is Susan Trio. I live at 43 Garage Road.
Hi, Susan.
And this is my second hearing, and I don't know if these issues have been addressed previously, so my questions may have already been brought up at some point. Has there been a discussion about the character of this building? What it's going to look like? Do we know what this building is going to look like?
I mean, we have the drawings and.
Well, I know there's drawings. Those are flat drawings.
Yeah.
But what I'm wondering about is, what is it going to look like? What are the materials that are going to be made out of? Is it a flat roof? Is it going to match any of the nature of the character of our town? That's one question.
I believe Rob, on the elevations, there's some details as to what the materials you're going to
Like
use.
what color is it going to look like? What are the signs?
Those are
what
things that
their
we have no
requirements
control
about
over
the
that,
signs?
Steve. These are things that are.
I mean, there's been superficial discussions about it. I mean, if and when we get to the point where you're granting a special permit, we'll get into the details.
Okay. So my second question then is about the potential fiscal impact. I'm wondering if there's going to be tax breaks for this company to bring their business to this town. I'm just asking, I don't know.
We don't,
I
that
mean,
doesn't enter our.
I'm not
that's
aware
part
of
our
any
discussion.
tax breaks being given by the town of Sunderland. I mean, we consider, you know, potential fiscal impacts, but I'm not aware of any incentives that the town is giving to.
Would that be a decision that's made here?
No.
Where would that be made?
We would have to go through town meeting, and that's not something that I'm aware of anything
Right.
being applied for. I'm sure they'd accept any tax breaks you want to give them, but they haven't applied for them.
I mean, I don't think that applies here, so.
No.
Thank you.
Real quick, Mr. Chairman, can I give you this? I'll give you this after the meeting. This is the elevation.
This drawing is on the website. You can
That's
see.
what I was wondering.
Yes.
Materials and colors and all that, so should be pretty descriptive right over here.
So this is basically going to be a box store?
Yeah.
Yes.
With a flat roof?
Yeah.
Yes.
Flat with a little-
slope, but yes, but essentially parapet wall, so it looked like a flat.
Is there a similar one nearby that we could go look at?
Yeah, probably fine.
Just plug it into your GPS.
I've visited several of these, because I drove through Westfield, says, oh, there's a Dollar General, so I walked in there, and there's one in Greenfield, they're all over the place. And, I mean, their general motif is like green on green, or
Right,
green and
in-
yellow.
in Greenfield, it's-
Let me, so, I mean, you know, there's a certain look to them. I
Right,
mean-
but in Greenfield, for example, it's part of a shopping mall. This is going to be a standalone building in the center of our town.
Yeah,
And that has a
understood.
That's what's
different
proposed,
Understood.
yes.
character.
That's what's proposed.
That's-
And we will act on
That's
what is
what's
proposed.
proposed,
That's
right.
what, we will act on what is proposed.
Yeah.
If it's helpful.
We don't do in the fine detail of color of the building and all that kind of stuff. We just
Who
don't
does
have,
that?
we don't have
But it-
control
but it
over
is-
that.
No, it actually is presented. So the plan before you has the color, so very specifically thin brick wainscoting color, 5W7, it's like literally specific colors, material types for the exterior of the building are on, there's a schedule for that, right here.
And we've put stipulations on buildings, of, storage buildings or whatever, it must be muted colors, or, if necessary. So, I mean, it could be covered in the stipulation, but, I think what they're proposing right there, they're proposing something, so.
In their Polito development, the developer, does have a website, and I do believe they have a number of stores that they've showcased on their website. You might want to take a look at that as well, give you some feel for what they've done in other communities. Again, if there's input, we'll try to take it.
Because there was a proposal for Cummington that I think was ultimately denied.
I'm not
Could
familiar
be.
with that one, probably because I didn't do it.
Could be. I don't know what, that's immaterial, everyone's different, and this is ours, so.
Thank you.
I'm Nancy Pick. I have lived at 187 North Main Street for 33 years, and I've been on the Conservation Commission for more than a dozen years, I think. One question is, Cliffside Apartments, as you mentioned, has a drinking water well that has a pumping zone that intersects with the property line of the development plan. A parking lot with associated automobile fluids, road salt, etc., can have an impact on their drinking water system. And I'm wondering if contact has been made with either a resident association or the owners, like have they been involved, because they are potentially drinking the runoff. So,
I think they're drinking their own runoff too.
they're drinking, that's fair enough, but, just for
I'm not sure their parking lots are attached to a.
So we can certainly show the well location. All public water supplies are listed with DEP. They have a very specific detail of what the well yield is. There's a radius, as I had mentioned, between 100 and 400 feet.
Are you communicating, like, have they you talk to them, and like, do they know that this is?
I don't, I would think, I talked to Fred Laurinaitis, who is our water commissioner, because we have a well, but it's up Clark Mountain Road, so he says that's, not really a factor for me. But he said, boy, if I had, that well at Cliffside, I would be here, I'd be very concerned about it, I'd be looking into it.
Just for a correction, there's 3 wells at Cliffside, 3 bedrock wells, maybe 600 feet deep total, or
So
each well.
relatively shallow.
Yeah. I'm just curious why they didn't show up on any of these.
Isn't it?
What?
Okay, see,
Yeah,
I don't know what I'm talking about.
The well screens could be anywhere from near the surface down to some depth. But I'm just curious why those locations never showed up in any of the diagrams or their interim wellhead protection areas.
We're not required to show them if they're outside of jurisdiction.
In the stormwater plan?
In the stormwater, are you saying it's not in here?
So the well radiuses, the radii that you're talking about don't intersect.
They do. Yeah, I can show you.
Okay, so with our site?
Yeah.
With our disturbance?
Yeah, in the northwest corner. Yeah.
With our disturbance, our work, our stormwater?
Yeah, in the northwest corner of the property.
You want to show me?
Well, we can go and look up on Mass GIS or.
So you're telling me that with our development here and our stormwater drainage,
It's on the very northwest corner of that little solid green area there.
the radius,
The northwest corner.
The northwest corner.
but not the well, the radius for the well?
The radius. yeah.
Okay, so not within what we're doing. So yeah, so the way the well radius works, it sounds like you probably
I'm
are
a
aware.
hydrogeologist.
Okay, so you know how it works.
Yeah.
Okay.
And
So
so
you know
these are interim wellhead protection areas too. So,
yeah, which we're meeting the requirements for.
I'm not quite sure, but,
That's what the peer review.
That's why we
Sure.
want a peer
Yeah.
review,
so, what would need to be done is you would need to do some kind of groundwater mounting analysis to look at how, your infiltration basins are impacting, the contributing area to those wells. But,
So the proper professional is the PE. Our PE will communicate with the PE for the town. They are intimately familiar with the DEP stormwater management standards. All these requirements, mounting analysis are required in certain situations. All that would be looked at through the peer review process and then provided to the public.
I would hope that the peer reviewer would be knowledgeable in this area too, that would be able to look at this
It will
with
absolutely.
that critical eye.
The stormwater standards, I don't recall exactly which volume, but there is something in there about mounting analysis and when a mounting
It depends.
analysis
It's
is
very
is
specific to
required,
the standard.
which isn't by any means all the time.
Correct.
Yeah, it's
Usually,
only.
usually if you're within a certain separation of groundwater. So-
Yeah, yeah, and if those conditions aren't met at the site, then there's no need for a mounting analysis, it's not required.
Well, I think that's up to debate as well. It looks like your subsurface, under the parking lot, what's the depth of that infiltration, I don't know what you call it, facility?
Your, structures.
I was just looking at the stormwater report, it says 3.75 feet,
Bottom of stone is 167.5.
inches?
No, that's the elevation above
Okay.
mean sea level.
On the
Based on
bottom.
the 1988 map.
Okay, and then how deep is it to groundwater below that point, based on?
I have to go through the report. I don't know if I have it on this sheet.
Do you want?
Estimated seasonal high groundwater directly adjacent is 159.5.
I have the report if you want
Well,
Yeah, so well,
Are those plates online? These, the
This is on,
plates associated with
I believe so, they're under the Rev B
Okay.
package. I mean, there's like, I don't know how many drawings there, there's like 18,
so
I
the
don't know.
DEP stormwater management handbook is very specific to the design of different types of basins.
Yeah.
So yeah, so the separate, so if you're trying to determine groundwater, we have no groundwater in one of our test holes. We have another one at 159.5. So 159.5, the bottom of the stone for our chambers is 167.5.
So,
Well,
It's interesting, because in the lead up, I guess the site description, I'm just looking for it, says that groundwater was found between 72 and, groundwater was encountered in 6 of the test pits and was generally at a depth of 72 inches to 120 inches below grade.
That's a great.
Yeah, so what I'm telling you is the actual elevation, not the
Right,
not the
yeah.
depth from the
Right.
surface, which I think you're referring
Okay.
let the peer review figure it out.
Yeah.
I mean,
to. And
seriously.
you're happy to,
Oh.
we're happy to take comments, if you provide comments to the board, have specific comments, we're
Yeah.
certainly happy to address them. We can have
Well,
our-
I do have some comments from Ellie that she sent to us, and she's a member of the Conservation Commission. I couldn't be here, and I got something from the chair. We got 2 people from the Conservation Commission here. So, you know, I think there's gonna be a lot of attention on this, and I think it's well warranted.
I think that sounds like a good process.
So, I think if there's no more questions, I think it's, yes,
Hilda Bailey, I live at the Social,
you live, social, okay.
which is across the street from where the Dollar General is supposed to go. Why Sunderland? Because you have existing empty storefronts in Hanley that would have greater traffic, better business.
Well,
Why Sunderland?
I-
Why waste the money building?
I'm sure that, you know, hey, this arrived in our its application shows up. I mean, we didn't pick it,
Actually, I
And-
was addressing Dollar General.
and I mean, I don't know how that's germane to the special permit process. I mean, that's, sorry, but, you know,
I'm happy to explain that that's not my specific role, but the developer works directly with Dollar General. They identify demographics, you know, population within a certain vicinity, I'm sure, traffic counts, and you guys met the criteria. Lucky you guys.
Lots of students.
Lots of students, yeah. So there's a reason why they want to be here.
What you've said, by the way, before are words of wisdom that I can say I have never heard from a board before.
And that's,
No,
I'm
for
probably
example-
in trouble for it now.
No, for example, when I represent opponents, which sometimes I do, what I say to people is, for gosh sakes, don't just come and spew out anything that comes to mind, because the board, what I tell them is exactly what you said. The board's criteria are in the zoning bylaw, and what you need to do, and it's online, is read those criteria, and you read them, and then you need to focus your comments on those criteria. And if, for example, you're opposed to it, then for gosh sakes, make your argument, but please focus on the criteria, just like what Rob's doing in his report, which is showing how we've met those criteria, and it keeps it focused, and it avoids wasting a heck of a lot of time. So thank you. So I wish every board would do that.
Well, respectfully, Hilda's question is under number 1 here. Social, economic, or community needs which are being served. What are they?
I can answer that too, by the way, because, to the board, to the chair. You are in between Amherst, Northampton, Greenfield, and basically, and I can see this for sure. I mean, I've got a degree in economics, okay? This type of store basically saves trips that would normally have to go to any one of those towns. And I think it's an excellent example. And this is what Toledo does and other people, and this is how a small box retailer like this has succeeded. They look for these holes, basically, where the big stores are far enough away that it's a lot more convenient. And that's how it serves the well-being of the community. If you need something that they've got, you don't have to schlep a lot farther for it. And that, I think, is a well-being to the community, in addition to, they're not getting any tax breaks. Commercial property, unlike houses, benefit the town because they add to the town's tax base. There's a net gain, unlike houses, which if you got 2 kids in the school, the house is a.
We can't use that. We can't use that when deciding.
I understand, you can't use it, but I think it's something that people obviously are concerned about. And so I think it's both a service, an access benefit, and a financial benefit to the town. Thank you.
Okay, so shall we talk about continuation dates? So, do we want to continue to 4 or 6 weeks? Or, I mean, we got some homework to do. The 2 attorneys have some homework to do. I don't know, Rob, you probably don't have much to do.
Nothing. So it's
But I mean, we're gonna
take
have
you better part of 3 weeks to get secure quotes, I would think.
at least. So I would say maybe 4 to 6 weeks. We the time frame to be.
I mean,
Quotes.
if you, so right now, when do you normally meet?
We meet as needed.
Okay. So in a perfect world, we would like to meet in September. And then if you have, can secure quotes, meet with you on those items. And I think in that time, hopefully the attorneys can powwow and come up with where they're at.
Do you like meeting on Wednesdays? Is that what you've been doing?
I try to avoid Mondays and Fridays. So,
The 24th,
is a Wednesday?
it is?
Wednesday, September. No, it's August, September. Okay, board, Wednesday, September 24th, is that a good day for us?
Good for me.
Okay. So we'll continue this hearing on Wednesday, September 24. One thing I would like to request, you're the travel study engineer, right? I would like to revisit that. When we were doing the travel study at the end of the last session, we had sort of a hard stop. We were in the middle of discussing things. And so, and some further questions have been raised that we would like to talk to the traffic study person. And I would ask, one of the questions I have that, it was classified as a variety store use. Somehow that doesn't quite seem right. I wonder what other uses are there, because, based on a variety store use, they said we're gonna have X amount of cars coming in, whatever.
So I do have the, and I can save it for next time, but I did pull the center variety stores and, a standard term. The Institute of Transportation Engineers have descriptions for the different land use codes, so I did pull that and can certainly share that or send.
Do they have other categories? I mean, because, I look at Dollar General and it doesn't strike me as a variety store. Or I like to know what else is a variety store? I mean, it's like.
So I can just.
But I don't
Yeah.
hear, but I'd ask you to take a look at if, is there such, it's more of like a mini big box. I mean, and I don't know if that's such a category.
The variety store specifically references the similarity to a dollar store that's in the description. And so that's where data has been collected at other similar uses, other dollar stores. So that's why we picked the
Okay,
one we
well,
did. Just
that is a question I'd like to touch on again.
Okay.
The other thing is that I don't know, I know how these corporations work. They took a very careful analysis of deciding before the Dollar General decided, before they said, I think we want to cite this and, bear the expense of, going through and getting a special permit, and having the engineers. Do they have, they must look at that, and they must go through and they go through a formula and they say, not enough traffic, not worthy, find another place. Did they have a study that shows how many cars, what kind of traffic they can expect? I don't know if that somehow could be factored into this, because we talked about, and you've reduced the amount of parking from the first set of drawings. I don't know,
So not that I'm aware of, I don't believe Dollar General has their own data set, but the Institute of Transportation Engineers trip gen manual is based on data collected at other dollar stores. That is all into that variety store land use code. That's kind of what the manual does. It collects and summarizes data to come up with the rates based on the trips in and out of similar sites.
Are you trying to establish that it wouldn't be a viable location?
No, not at all. I'm trying to, the biggest question that comes out of my mind out of the traffic study, I see the cars going this way and, they show all that stuff. I said, okay, more or less, I can understand that. I'm just trying to, do we have a good handle on how many cars are gonna, is expected to go in there?
I think it's fair to say, in understanding what Bowman has done and what they've done on the multiple projects we worked with them on, they're relying on very specific, detailed data that's collected by the premier standard, industry standard.
Let me just say, I'd like to take a deeper look at that, and then that we can talk about when we get into the traffic study again.
So I guess what I'm saying is that information is less than site-specific. That is more data set based on the industry standard. What other solutions?
Our special permit will be site-specific, so I know.
But I don't think I said it right, but this is the data that everyone in the entire country uses. Am I wrong?
Maybe what we could do is, and I don't know, has Bowman done other Dollar General stores? Then maybe what you could do is look at studies that Bowman has done specifically for Dollar General, for this same company's stores, and look, compare the square footage of the store, and then see if the other studies use the same Institute of Traffic Engineers category.
I mean, that's the most applicable land use code, so that's the one we look for the one that is most consistent with the proposed land use. So it's saying specifically in the description, also called dollar store, that is what we should go with.
Okay, I don't know, that's something that troubles me.
What specifically troubles you, just so we can try?
Do we have the expected number of cars, the traffic, or the car volume that this use is gonna generate? Do we have it, right?
Is there a similar one on a state highway, with similar traffic? Kinds of a similar example?
I don't know, do they base it on square footage? That doesn't seem to make sense, I mean, you
So
got
they
10.
they collect the in and out, all the trips in and out of similar stores, and they aggregate that and generate a rate based on square footage. So X number of trips per square footage based on all the data collected and the characteristics of those sites. So kind of what you're asking for, looking at another Dollar General and the trips associated with that is what the ITE trip generation manual does.
And it's probably safe to say that the last thing Mr. Colito wants is either to have people who can't find a parking space or pay a fortune to pave areas that aren't going to get used. I mean, that, I think, is part of what any store like, and that's why they
I'm most concerned about the traffic impact. I have a feeling that the parking is more than adequate. That's not the point of my question. I gotta tell you, traffic flow and safety is a big problem with this. No matter where you put the driveway, I think I told you, the only place that I'd feel comfortable you put the driveway is at that traffic light. And if we underestimate the amount of cars that are gonna go in there, that's gonna make a traffic problem worse. So that's what I'm wrestling with, okay? And, maybe it is what it is, and maybe that's truly accurate, but, in my gut, it doesn't, I'm not sure.
That's why we, as design professionals and traffic engineers, don't rely on our
Well,
gut.
and I'm just asking, I'd like to revisit that.
That's correct.
And if you could provide some more, substantiation or, something to reinforce it, okay, but.
Will people be able to make a left onto 116?
Are you
No,
looking,
you're not
are you
gonna-
looking
you're
to
not-
find out how much the traffic will increase due to the store being there?
Yeah.
It's on the report.
I know it's on the report, and it's based on, it's a variety store use, and they look it up,
But I think the hard part is that there's already a lot of traffic there. So if you add 10 more cars, it doesn't really increase it.
Yeah, but if you had
by
100 more cars, that's gonna make it a heck of a lot worse. I'm
I see.
exaggerating for effect, so,
I'm just
well,
trying to figure out why your anticipation of a lot of extra traffic to me isn't my expectation.
well, the traffic report does say, this use is expected to generate this much traffic.
Can we just go back, Mr. Chairman, sorry. There was a lot that was said in that statement. You said no matter what the traffic report said, you had specific concerns with circulation, site access, safety, etc. So in the report, I just want to go on the record. In the report, and I'm going to ask Emily to reiterate this or clarify this,
Well,
but in the
reiterate
yeah,
next
she's the
time.
traffic person.
Yes.
So I'm going to ask Emily the question. Is there anything in the report to support the statement that this is a specific safety concern with the existing turning movements in and out and the crash data that's available for this area?
No. We've reviewed the crash data, it's all below average at our study area intersections.
I understand all that, and I don't even question that.
That's what your question was. So you're saying you don't question the circulation in and out?
I understand, again, you know, do we have the amount of traffic that's gonna be generated by this use right? And so I need some convincing on that. I mean,
So what if we were to solicit a specific, who can you go to at ITE that for a further description of
I
the?
mean, the manual provides descriptions, I did bring it to read, I mean, I can,
okay, well,
I can send it in advance, whatever's.
I mean, maybe you have no answer for my concern, but I'm just telling you something I'm kind of wrestling with. And, you know, anything you could do to, you know, to convince me that, you know, we have this nailed right. I mean, that's all.
Can I ask a question? If there's going to be something at the next meeting that you're gonna provide us with, if you could provide it like ahead of time, and then it can be distributed, you figured out how to put stuff on the website, we can like make sure that it's available ahead of time. I think that would be helpful. Just so we can review it.
The traffic report is up there as well.
Yeah, but she's saying that she has definitions.
Well, anything,
Description of the land use code, just to make it clear, you know, that it does specifically state the dollar store. It's just the short description, but if it's something we want to share, I can certainly provide it.
I'm sorry, I'm sure I'm just bludgeoning you guys, and I
I had hair when I started doing this.
No, but you're asking the right question, because in fact, is the traffic study based on the right?
Motion to adjourn.
yeah.
I just want to point out that we continued the hearing 15 minutes ago, so half the audience left, or a third.
Yeah, we're just, we're saying that what I want to get, I'd like you to, if you could address my concerns at the next hearing. Maybe you can't, maybe, you know.
Sounds great. Thank you.
The hearing is continued to Wednesday, September 23rd at 7 o'clock.